Hello friends, I welcome you all in a course titled at Hindu Personal Law including Marriage and Succession. In today's lecture, we will focus on the Hindu marriage and its nature. But before starting the class, I want to summarize what we discussed in the last class. In the last class, we try to understand the general introduction of Hindu Marriage Act, where we understand the preamble of the Hindu Marriage Act amend and codify law relating to marriage among Hindus. Means Hindu Marriage Act amended a Shastric Hindu law, codified the practices which was prevalent in India before the enactment. And among Hindus means act only covers those marriages which happens within two Hindu. And friends, we also discussed that act law relating to marriage. Law relating to marriage means provisions related with the formation of marriage, dissolution of marriage, and the third is any other matter related with marriage. Formation of marriage means condition of Hindu marriage, ceremonies of Hindu marriage, registration of Hindu marriage, and dissolution of marriage provisions includes judicial separation, divorce by mutual consent, when you can marry after the divorce. These provisions are relevant, friends. And any other matter related with marriage includes the restitution of conjugal rights, legitimacy of children, judicial procedure and precedent principles under section 23. So this is about the scheme of Hindu Marriage Act. Friends, in the last class we also discussed the overriding effect by explaining section 4 of the act. Section 4 clearly provided that after the passing this act, for which the provision is made under this act, application of Shastric Hindu law is not possible. And as well as this act have overriding effect over other legislations. But the important point is, friends, for which the provision is not made, we may apply the Shastric law. Therefore, this act is not comprehensive code. What is not mentioned in this act may be applied on the basis of the Shastric law or custom which was prevailed before this act. Friends, we also discuss about the saving clause. Saving clause means certain things are not comes under the domain of this act, where we discuss about the concept of pre-act marriage. We also discuss about the customary divorce. Means, friends, today customary divorce is possible. The only condition is custom must be a valid custom. And we also discuss about the marriage under the Special Marriage Act, and we also discuss that protection of certain pending proceedings. We also understand the detailed background of the Hindu Code Bill. We also discuss the need of codification. We also discuss the 6 chapters, 30 sections. We also discuss that act enacted in the year 1955, enforced on 18th May 1955. We discuss every aspects related with the primary information of Hindu Marriage Act. In today's lecture, I will focus on Hindu marriage and its nature. Friends, the learning objectives of this lecture includes meaning of marriage, nature of Hindu marriage, effect of Hindu Marriage Act 1955 on Hindu marriage, and the essential ceremonies of the Hindu marriage. These are the learning objectives of the today's lecture. Friends, I want to start with general introduction on marriage. The marriage is one of the most significant social institution of human civilization. The marriage is a social institution in which there is a social recognition of the union between the man and woman. The institution of marriage did not exist in a primitive society. Man lived like an animal and they focused on hunger and shelter. But in the same course, individual lives evolves into the social life due to the influence of civilization. the acquisition of knowledge, and the development of religion. The development of humanity provides a way for the institution of marriage, and the institution of marriage play a crucial role in shaping the life of individuals as well as the life of community. Friends, we are thinking about the free sex society in past, but now the sex is regulated, and Indian society, especially when we considered marriage as a sacrament, we developed certain conditions, certain objectives which converted marriage as a sacramental union. This is the fundamental observations about the marriage. Now I want to focus on the marriage and the nature of marriage under the Hindu tradition and Indian tradition. Friends, in the past we recognized 8 different kind of Hindu marriage. 8 different kind of marriage broadly may be categorized in 2 broad category. One is the approved form of marriage and disapproved form of the marriage. Approved form of marriage includes Brahma, Ars, Dev and Prajapatya marriage, and disapproved form of the marriage includes Asur, Gandharva, Paisach and Rakshas marriages. Such kind of classifications exist in India. Why it is exist? Because for the purpose of social protection to the women, different kind of the relations recognized in the form of different kind of marriage. This is the vastness of the thinkers who think about the different kind of marriage to accommodate each and every kind of relationship and regulate each and every kind of relationship, legal or illegal, which exist in a society by different standard and parameters. Now I want to focus that Hindu marriage is regarded as a sacramental union because its ultimate purpose is attainment of moksha. Because we are talking about the 4th different kind of purusartha, dharma, artha, kam, moksha, and moksha is ultimate and moksha is possible through the way of marriage. Friends, Apastambha states that marriage is meant for doing good deed and for attainment of moksha. Gautam Dharma Sutra clearly identify the objective of the marriage. Friends, in Manu Smriti, Manu states that I hold your hand for Saubhagya, that you may grow with your husband. You are given to me by the just, by the Creator, by the wise and learned people. These are the blessings which exist at the time of marriage, which signifies the importance of marriage in Indian tradition. In the old text, wife recognized as Ardhangini, half of the man. We are well aware about the concept of Ardhanarishwar, which frequently used for the purpose of Vishwanath Mahadev. Friends, as per the Satpat Brahman, wife is considered the half of the husband. A man is only half until he married. Means you cannot be recognized a complete man without marriage because of the concept of the Ardhanarishwar, Ardhangini and everything, friends. Friends, the Adi Parva of Mahabharata also highlights that the importance of wife in the personal, social and religious aspect of the human life. Therefore, in ancient India, the marriage is one of the essential sanskar, means sacrament for the Hindus. These are the unique features of the marriage which exist in our tradition. Friends, under the Vedic system, Veda states that dharma must be practiced by the man together with the wife. This is a very important point. A man, a male is not authorized to perform religious rites alone. We have a number of the story where golden stone of Sita, golden statue of Sita developed by the Ram for the purpose of performing the yajna. This is the rule of the Dharma Shastra. In Hindu view of life, marriage is necessary for the happiness, family and the perfection. Friends, Hindu marriage is considered a sacred sacrament and holy union between the man and the woman. Hindu have embraced the religious and sacramental nature of marriage and rejecting the concept of it being merely a contractual arrangement. This is the fundamental discussions. In the Western society, they think that they enter into the contractual union, but in our tradition, no, this is not a contractual union, it's holy union, a kind of sacrament. It is necessary to perform for the perfect life. This is the concept, friends. Therefore, Paraskar Griha Sutra identify the objective of the marriage. Dharma prajaratyartho hi vivaha, means Paraskar Griha Sutra identify three objectives of marriage: dharma, praja and rati, means dharma, son and sex, three important component of the marriage. Therefore, if you examining the entire Indian tradition, you are bound to conclude that in India we discussed and considered marriage differently, and it is totally different what we think today about the marriage, because where we are living about the contract marriage, where we living about in an era where we think about the live-in relationship like management. Friends, now I want to focus on the Hindu marriage and its nature. In a case of Monmohanty Basant Kumar Singh, the Calcutta High Court observed that Hindu marriage is a sacrament, a union, an undissolvable union of flesh with flesh, bone with bone, and to be continued even in the next world. Means this relation not exist only this practical life, this real life, it also exists beyond the life. Therefore, this is a union where in India we are using a Sanskrit terminology. This is a kind of relationship which exists janma janmantar. Friends, in a case of Gopal Krishna versus Mithilesh Kumari, the Allahabad High Court observed that the institution of marriage under the Hindu law is a sacrament and not a mere social legal contract. In Hinduism, marriage is a process by which husband and wife become one. The view of the Calcutta High Court and view of the Allahabad High Court reflected that Hindu marriage is unique and a sacramental union. Very interestingly, in the year 1025, Supreme Court again observed the religious importance of the Hindu marriage. In a Dolly Rani versus Manish Kumar Chanchal case, in the year 1025, Supreme Court held that a marriage is not an event of song and dance, winning and dancing, or an occasion of demand and exchange of dowry and gift by undue pressure. A Hindu marriage facilitates procreation, consolidate the unity of family, and solidify the spirit of fraternity within the various community. After all, a marriage is a sacred, for it provides a lifelong dignity, affirmity, equal, consensual and healthy union of two individuals. It is considered to be an event that confers salvation upon the individual, especially when the rites and ceremonies are conducted. Manish Kumar Chanchal case rejected that only on the basis of registration of marriage, a marriage cannot be considered valid unless marriage is performed as per the religious requirement, as per ceremonies, friends. Therefore, Dolly Rani and Manish Kumar Chanchal case is very relevant in order to understand the nature of Hindu marriage, and very important is, friends, the Supreme Court again affirmed the nature of Hindu marriage in the year 2024. Friends, now the question is, what happened after the codification of Hindu law and after the enactment of the Hindu Marriage Act in the year 1955? Because, friends, prior to the enactment of the act, it was widely accepted that Hindu marriage was sacramental institution. However, after the enactment of this act, two differing views emerged regarding the nature of Hindu marriage. One considered it is a sacrament, another considered that it is a contract. Now the question is whether it is sacrament or it is contract. Friends, now we can raise certain fundamental question. Did Hindu Marriage Act of 1955 introduce the concept of civil contract into the private sphere of family? These questions to be answered when we are going to discuss about the nature of Hindu marriage within the Hindu Marriage Act, friends. Friends, nowadays still Hindus have two options. Option one is they may marry under the Special Marriage Act, and if they are marrying under the Special Marriage Act, they may enter into the civil contract. But when they are selecting the option of Hindu Marriage Act, then marriage obviously a sacrament and holy union. Friends, now I want to focus and conceptualize the different argument. The few scholars arguing that Hindu marriage is contract. Why they are arguing in such way? They argued that Section 5 of Hindu Marriage Act 1955 laid down the condition for a valid Hindu marriage, including the legal capacity of the party, the requirement of the valid consent, and the prescribed minimum age of the parties to the marriage. Means capacity, consent, and minimum age. Three different criteria especially laid down by the Hindu Marriage Act. These criteria is also very crucial for the contract also. Therefore, Hindu marriage is a contractual union, not a sacramental union. Friends, by supporting in these arguments, they also tell us that the provisions of divorce is also introduced by the Hindu Marriage Act, and therefore it is very clear that Hindu marriage may also be breached by either party of marriage. And Hindu marriage also introduced the concept of remarriage and also introduced the concept of widows and widowers remarriage. By this argument and conceptualization, they argued that by introduction of such kind of provisions, why you are arguing that Hindu marriage is still a sacramental union? Therefore, friends, it is necessary to identify the arguments and compile the arguments those counters such narrative. Friends, now the counter argument is very clear. Friends, the fundamental argument is essential requirement of contract are lacking in Hindu Marriage Act 1955 because of the following reasons. First is absence of the offer and acceptance. Friends, we are aware about the idea of Muslim marriage where they talks about the Kabul. Therefore, they involve in a kind of offer and a kind of acceptance, but under the Hindu marriage there is no such kind of offer and acceptance, formalized offer and acceptance, friends. The second is, friends, absence of consideration. When you think about the contract, you cannot think without consideration, because no contract can exist without consideration. Friends, under the Hindu marriage system, we never recognize any kind of considerations. If you thinking that dower or dowry may considered as a consideration, it is a wrong notion, because an illegal things cannot be considered as a consideration. Therefore, idea of consideration is missing in this act. Friends, the primary intention of marriage is the religious as per section 7, because section 7 recognizes the completion of marriage by the performance of religious rites and ceremonies. There is no ceremony and rites is applied in a case of contract. Contract is free from marriage, any kind of ceremonies. But section 7 clearly mentioned that marriage must be binding at the 7th step. Means we cannot imagine about a marriage without any kind of ceremonies. Therefore, friends, I summarized arguments of the people who are arguing that Hindu marriage is a contract. I also summarized those people who are arguing that Hindu marriage is not a contract. Friends, the idea is very clear and simple that marriage is one thing and the contract is another thing. Contract is commercial transaction. Friends, we already understand the development of Hindu law, entire tradition of Hindu law, where we never recognize the concept of marriage in the light of contract. It is totally different, friends. We recognize Vivaha as a sanskar out of 18 sanskar. Therefore, it cannot be treated as a contract. Friends, we are living in a 2025, but it not mean that now we change the nature of marriage. This nature of marriage is very crucial when you are interpreting the provisions of Hindu Marriage Act. Therefore, I stressing that is still in 2025 Hindu marriage should be considered as a sacrament. It is not a contract like any kind of practices which is prevailing in different country and among the different group of the people. Friends, now I want to focus the opinion of the mullah. Mullah noted that Hindu marriage under the act is not entirely or necessarily a sacrament, but union of one man with one woman. Customary rites and ceremony creates a relation and status not imposed or defined by contract but by the law. Friends, the relationship of husband and wife in India, especially in a case of Hindus, neither defined not imposed by the contract. It is defined and imposed by the law. Law means law which is applied before the enactment and law which is nowadays prevailing. Therefore, by any standard, it cannot be compared by the concept of the contract. Now, I want to focus on a case Sivanand by the Madras High Court, where the court observed that the marriage is binding for a life because marriage rites is completed by Saptapadi before the consecrated fire, creates a religious tie, and the religious tie once created cannot be untied. It is not a mere contract in which a consenting mind is indispensable. The Madras High Court also held that this is a ties which cannot be untied on the basis of contract and on the basis of your wish. Therefore, Hindu marriage is still a sacrament, friends. Friends, now I want to focus on the ceremonies of Hindu marriage. Why ceremonies of Hindu marriage should be discussed when we are discussing about the nature of Hindu marriage? Because section 5 talks about the condition, but section 7 is about the ceremonies related with Hindu marriage. Ceremonies is also binding because the marriage is not considered complete and binding without the completion of ceremonies. Therefore, friends, Hindu marriage is a sacramental union. Section 7(1) provides that marriage may be solemnized according to the customary rites and ceremony of either party to the marriage. Marriage may solemnized as per the customary rites and ceremony either party thereto. This line is very clear. The term may, which is mentioned under section 7, is interpreted by the court as a must. Means marriage must be solemnized as per the customary rites and ceremony of either party thereto. And marriage will consider complete and binding at the 7 steps taken by the persons, friends, by the parties of marriage. Sometime custom of the parties to the marriage may differ from each other. Therefore, act allowed to perform the ceremonies either party of the marriage. Means marriage may be solemnized either from the perspective of the one party, either from the practices and ceremony of one party of marriage, or by the practices which is prevailing in by the both community, friends. Friends, the condition laid down under section 7 must be performed. Therefore, no marriage is allowed by agreement under the act. In a very famous case, Bhaushankar Lokhande versus State of Maharashtra, the observation of Supreme Court is very crucial, friends, where Supreme Court observed that unless a marriage is celebrated or performed with proper ceremonies and in the due form, it cannot be said to have been solemnized. The bare fact a man and woman living as a husband and wife does not normally give them the status of husband and wife. Means performance of ceremony is very crucial because it is important condition for a Hindu marriage. Friends, in a case of Surjit Kaur versus Garaj Singh, the Supreme Court noted that parties live together as a husband and wife without performing the essential ceremony. In such situation, living together as a husband and wife by itself would not confer a status of husband and wife. The same idea further Supreme Court projected in the case of Dali Rani case, where both the parties not involved in any kind of ceremony but they fraudulently registered their marriage. But the court concluded that registration is not an evidence of marriage unless and until ceremony is not performed by them. Their union cannot be considered as a marital union under the Hindu Marriage Act. Means Supreme Court was consist in a case of Surjit Kaur and Dali Rani case, means customary rites and ceremony must be performed for the purpose of ceremony. Friends, section 7.2 is very critical and identifies Saptapadi as a significant ceremony of the marriage. Traditionally, Saptapadi is recognized an essential ceremony. The marriage ceremony, which includes very popular ceremony, it means bride and bridegroom together take 7 rounds or 7 steps before the sacred fire. Friends, the form of Saptapadi may vary according to the custom. In Arya Samaj, they only recognize 4 rounds. In certain society, they recognize only 5 rounds around the sacred fire. In certain community, it is recognized as a 7 step before the sacred fire. Friends, what is the point? The point is form of Saptapadi and second is performance of Saptapadi. Performance of Saptapadi is mandatory, but form of Saptapadi may vary as per the customary practices prevailing within the parties of marriage. Means whether you take round around the sacred fire or you are going to take 7 steps towards the fire, means form of Saptapadi is one thing, performance of Saptapadi is another thing. Performance is mandatory. Form may vary as per the customary rites of the parties who going to marry. This is the point which should be focused about that. Friends, in the case of Shanti Dev Berma, friends, where the court held that marriage ceremony includes the Saptapadi, marriage becomes complete and binding with the 7th step and 7th round. Means what is the actual rites it should be performed for the recognition of the marriage. It is important to note that the observation of rites of Saptapadi is essential for those parties whose rites and ceremony include Saptapadi. Friends, I am very clear that suppose 2 parties going to married under the Hindu Marriage Act. In their community, they not recognize Saptapadi, they are not bound to follow Saptapadi. Suppose where in any one of them Saptapadi is recognized, then they are bound to follow Saptapadi, perform Saptapadi. But what should be the form of Saptapadi is totally dependent on the custom prevailing within the community of them. This is the observation. We should be careful about this observation. Now friends, I want to focus on Kanyadan. Friends, Kanyadan is terminology not mentioned in the section 7 of Hindu Marriage Act, but Kanyadan is also recognized under the Hindu marriage tradition. Friends, it is one of the most important rites of the Brahma form of the marriage. It means the gift of a daughter to the bridegroom by her parents or guardian. It is declared as a pious duty of guardian by Dharma Shastra. Kanyadan cannot be ignored because Supreme Court held in a case, the Bhau Shankar Lokhande case, where Supreme Court held that marriage ceremony must be proper and must be in due form. Must be proper and must be in due form. Means, friends, if Kanyadan is essential for both the parties to the marriage, then it has to be performed by them for the validity of marriage. Means the applicability of Kanyadan is totally dependent on this fact that whether Kanyadan is essential within both the community or not. But I want to clarify the law, friends. Law only focus on Saptapadi. Saptapadi is essential. It not talks about any other customary rites and ceremony. But law is also very clear that marriage must be solemnized as per the customary rites and ceremony of either party there too. Means whatever customary rites and ceremony is there, they should follow this. But if Saptapadi is there, you are bound to follow and perform Saptapadi. But the form of Saptapadi is dependent on the practice of your community and society. Friends, by this discussion, we may conclude our discussion. Under the Hindu system of law, two Hindus who want to enter into the civil marriage may do so under the Special Marriage Act. Special Marriage Act, they may claim that their marriage is a contractual union. But however, if they choose to marry in a sacramental and ceremonial form of marriage, they are bound to recognize their marriage under the Hindu Marriage Act. Then they are bound to perform the ceremony and customs as per section 7 of Hindu Marriage Act. Therefore, under the act, a Hindu marriage is monogamous and must be solemnized to the performance of essential rites and ceremony according to the practices, must be free from any incapacity in the parties to marry, such as being within the degree of privated relationship or sapinda relationship. Friends, now by these discussions, you may think about certain points. The points are: why was the idea of divorce opposed in traditional Hindu society? Is it possible for a marriage to be both sacramental and contractual union? How do the ceremonies and religions rites maintain the sacramental character of Hindu marriage? These are very important idea. On that basis, you can evaluate the entire discussion. Friends, before closing, I want to summarize my lecture. Friends, the question is whether what is the nature of Hindu marriage? Nature of Hindu marriage is sacramental. Why? Because Hindu understand marriage as a sacrament, as a dharmic duty. Because marriage is closely related with the Purusharth, Dharma, Artha, Kam, Moksha, and we cannot perform the rites and ceremony without the wife. Therefore, wife is recognized is essential for the social life. Therefore, in India, in Bharatiya tradition, we have a different interpretation of marriage. And Indian legacy, marriage is considered a sacrament. We should keep in the mind this idea. Friends, why I am focusing on the nature of Hindu marriage? Because once you understand the nature of Hindu marriage, then you apply the entire law in the context of the nature of marriage. Therefore, understanding the nature of Hindu marriage is very crucial. Friends, the arguments where the scholar argued that due to the Hindu Marriage Act, certain ideas of contract is introduced in the domain of Marriage Act. Therefore, now Hindu marriage is a contract. Answer is no. Still Hindu marriage is not a contract, because essential of contract is technically missing in Hindu marriage. There is no consideration, there is no offer and acceptance, and there is no ceremony and customs prescribed for a contract. Therefore, this is still a marriage. Friends, why this is a sacrament? Because in 2024 Supreme Court itself observed that mere registration not provides you status of husband and wife. Your marriage is not considered marriage unless you not observe your marriage as per the customary rites and ceremony, friends. This is the crucial point, because Supreme Court clearly mentioned that the marriage is not a performance of dance and song. Marriage is to perform customary rites and ceremony. Therefore, friends, by examining the entire legal traditions, we are compelled to say that Hindu marriage is a sacrament. Yes, I am supporting somehow the argument of Mullah, where Mullah concluded that the obligation of Hindu marriage, an obligation on husband or wife, is not imposed by the agreement between them. It is imposed by the law, and law includes Shastric Hindu law also. Therefore, you can't say that it is a contractual union which emerges because of a contract. No, this is not a correct idea. Means, friends, the tradition of this society, observation of the legal provisions, and conclusion of Supreme Courts bound to conclude that Hindu marriage is a sacrament. This conclusion leads very important and crucial role in order to explain and interpret the different provisions of Hindu marriage acts. Thank you, friends. Thank you for your patience.